do something which can put the organization into trouble. And in general, we have seen it's a practice. Say, for example, board of directors are supposed to approve the director's report in a board meeting, which is to happen on the day when the accounts are approved. But in a number of cases, the director's report is approved only after a month or so, and we get mails being sent by one person to the other saying that this clause is to be inserted in director's report, and all. Those kind of mails can definitely create problem for company secretaries. We have to draw lesson from those company law practices as well. Next is section 4, which talks of abuse of dominance. Nothing wrong in being big, but if you are big, behave like a big brother. You are not supposed to abuse your dominance. The dominance is also defined under the law in a subjective manner. No arithmetical numbers are given. We are supposed to take shelter of section 19 bracket 4, where so many parameters are given, and organization declared to be dominant on any of those parameters would be a dominant enterprise. And once a dominant enterprise follow any of the practices which are listed under section 4 bracket 2 would be deemed to be guilty for contravening section 4. No rule of reason test, fortunately or unfortunately, is available with reference to the practices followed by a dominant enterprise in the relevant market under section 4. So to that extent, I think, Mr. Bhatia, I am covering what you could not communicate. Now, these are the practices which are deemed to be anti-competitive if followed by an enterprise who is dominant in the relevant market. We have an interesting case where the company secretaries could play a better role. In this case of Jindal Steel versus Steel Authority of India, the order was passed under section 26 bracket 6 after the detailed inquiry, and I will just read as to what was written in the order. The Director General has made reference to the minutes of the 270th meeting of the Board of Directors of Steel Authority of India Limited, held on 28 May 2001, wherein the board has acknowledged the need to meet the threat of competition posed by setting up of a new mill by Jindal Steel. Now, the investigation took place somewhere in the year 2009 or 10. But when the investigation was on, the authorities went back to the board meeting minutes of 2008, 7, 6, 5, 4, 3, 2, and finally in the minutes written by the company secretary or secretarial department of the company concerned at that point of time, they found something which was objectionable. Now, this is an area where company secretaries can genuinely play a role, provided that they have full understanding of the competition law. Don't write something in the minutes which can, at a later stage, be termed as creation of anti-competitive scenario. Mr. Bhatia repeatedly said about the circumstantial evidence. Yes, with reference to section 3 and section 4. Normally, evidences are to be gathered from the circumstances happening around. And this is a case where in the minutes they found something which then could be taken to mean that yes, it was a case of a dominant enterprise talking about the threat being posed by a competitor. It says in the minutes there was a mention of JSPL's aim of setting a rail manufacturing unit. It was also mentioned in the minutes that due to competition which is going to come due to the entry of JSPL, now you are trying to create entry barriers sort of thing. In the market for rails, Steel Authority of India Limited should upgrade the facilities for the rail and structural plant. Well, if this kind of entry prompts you to innovate and improvise your services, your goods, nothing wrong. Competition Act is all about it. But if you think in terms of removing that upcoming competitor right out from the market, this is something which is definitely objectionable. And this kind of notation should not have been there in the minutes which were drafted by none other than our own professional team. Again, as I said, with reference to section 19(4), because if enterprise is to be held guilty under section 4, it has to be proven first that the enterprise is a dominant enterprise. Section 19(4) gives a number of parameters. Some of the parameters are directly connected to our activities. There was a case where a statement was found by the chairman in prospectus, where the chairman said that our enterprise is the largest enterprise in the world. Now, this kind of statement appearing in the prospectus is a statement by the organization concerned that yes, we are big, we are dominant. In another case, full page ad was given on the foundation day of the organization concerned saying that our market share is 93%. Now the very first trigger generally with reference to abuse of dominance is the market share. If your market share is 25 or 30+%, there is an assumption that you are likely to be a dominant player. Now if you are releasing this kind of ad in the newspaper saying that we have the market share of 94%, it's an open admission that we are a dominant undertaking, and the moment you are a dominant enterprise, you follow any of the practices given under section 4 bracket 2, you are guilty. Another case, scheme of amalgamation. In fact, before the law came into force, because section 3.4 came into operation only from May 2009, I got a call from a large conglomerate saying that we are going in for a scheme of amalgamation. Do you think that this would be a proper scheme? Now in the scheme of amalgamation or merger, we are supposed to give the rationale for amalgamation. In that scheme, they very boldly told that as a result of this amalgamation or merger, we would be having 90% market share, we would be the large enterprise in the country. Now, if this kind of statement are appearing by way of rationale to the scheme of amalgamation, you are inviting troubles with reference to section 4 if the relevant practices are followed. And again, pricing has a major role to play with reference to section 4. We also have a set of specific regulations, CCI determination of cost of production regulations. Because whether it's a case of unfair pricing or predatory pricing or differential pricing, everywhere pricing will have a role to play, and these regulations again are practically connected to our professional activities. As sir also said, our syllabus is wide enough to cover all these areas of activities. We have studied them in detail as a student. Now if those studies can be converted into practice, it can definitely be a good area for us. The third pillar, combinations. Mr. Sharma, you could not say many things. This book was released in the morning. Practically whatever you could not say is finding a place in this book. All those cases are covered, so you don't have to regret. Practically your message would reach the people. For the sake of quick repetition, combination generally includes three kinds of cases: acquisition of shares or assets or voting rights or control, category 1. Category 2, you are engaged in a particular type of activity, you acquire control of another enterprise engaged in the same kind of activity. And number 3, yes, closest to us, mergers or amalgamation pursuant to section 391 to 394 under the Companies Act 1956. So these are the three areas which are covered by section 5 and 6 of the Competition Act. And I personally feel if we have to, well, I'm talking anti-competition, but if we have to share the market relating to the practice under the Competition Act, there can be very clear demarcation. Let combination related provisions be practiced by the company secretaries because they are good into it, and let provisions relating to section 3 and 4 be practiced by the lawyers because they are good into it. I think Mr. Sharma would agree to it. Of course, we don't have to believe in all that. We believe in level playing field, which is created by giving authority to all the 4 categories of professionals in the Act. There are exemptions. Mr. Sharma has already explained to us, so won't go into detail. There is a requirement of prior notification, and this prior notification happens through filing of forms. We, the company secretaries, can definitely be termed as super experts as far as the filing of forms are concerned. Now, CCI would be introducing filing of e-forms, something which we have been doing from 29th February 2006 on the portal of Ministry of Corporate Affairs. We have seen various phases of filing of e-forms under the Companies Act 1956 earlier, and now the Companies Act 2013. If this is allowed under the Competition Act, e-filing of Form 1, Form 2, Form 3 is permitted, perhaps we would be the best equipped professional to do the task. These are the forms which are to be filed. Form 1 is to be filed in certain cases. I think in 95% cases which have been decided by the Commission, Form 1 has been filed. Form 2 is to be filed in cases where there is a possibility of creation of anti-competitive scenario because both the parties, in case of horizontal combination, may have a market share of more than 15%, or in case of vertical combination, can have a market share of 25% in the respective of areas of activity or collectively put together. Form 3 is to be filed where FII or joint venture fund or a foreign institutional investor or a bank acquire shares pursuant to some kind of covenant in the loan agreement, there we are supposed to file Form 3. It's a different issue that till date only 4 cases of Form 3 have been filed. One of them had to be rejected on technical ground because it was more acquisition pursuant to a contract and not a loan agreement. In other 3 cases, yes, all the 3 forms have been registered. So what I'm trying to say is that we, the company secretaries, are too good in electronically filing the form. We can think of venturing into this particular area, something which is going to be a reality perhaps in the year 2015 itself. These are the probable effects of a combination. There is a possibility as a result of the combination, a dominant enterprise might be created and which might abuse its dominant position in future. In that case, it's known as unilateral effect, which may be objected to by the commission. Or there is a possibility that when lesser number of players are left in the market as a result of composite combination, then the number of players would be reduced and the possibilities of them entering into any kind of anti-competitive agreement are increased. In that case, again, commission can object to such combinations. There is another interesting provision which Mr. Sharma also mentioned, that there is a process of informal consultation. At times we are not too sure because the thresholds are given in the form of value of assets and turnover. We are confused at times as to what is to be included, what is to be excluded. The definition, unfortunately, is not very clear with reference to the term turnover as well as the assets. In such cases, again, we can approach the commission. Now, when I talk of we, the company secretaries in practice or in employment, are fully equipped with the affairs of the company concerned, and we can definitely give proper information to the commission and ask for their informal version whether this particular case or proposed combination would fall into the brackets of section 5 or no. With reference to combinations, again, as I said, company secretary is fully equipped to handle cases under section 5 and 6 with reference to combinations, whether it's a case of determination of assets or turnover, it's a case of drafting of non-compete clause in the agreement which is to be executed at the time of acquisition of shares or voting rights or assets or any of these cases put together, deciding as to what can be the market share of the combined entities, the group or control impact. The word control has a major role to play with reference to section 5 and 6. And it's not, we are witnessing various phases of control in the orders passed by the commission from time to time. We have direct control, we have indirect control, we have negative control, we have positive control. So again, these issues can be understood by a company secretary in a better way and can be handled comfortably. Compliance report, in certain cases, commission has asked the merging parties or combining parties to give a compliance report. Now, those kind of reports can be prepared by the combining entities in consultation with the company secretaries because we are supposed to be good compliance officers. Filing of forms, as I said already, it's our area. Divestiture of assets. Now, whenever divestiture of assets takes place, as Mr. Sharma said, in 2 cases, in case of Ranbaxy, Sun Pharma, and in case of Lafarge Holcim, they have decided that certain assets are to be divested. Now, this whole process has to be overseen by an independent firm of management consultant or management experts. Large firm of practicing company secretaries definitely can think of getting appointed to do this particular task on behalf of the commission. The company secretary can act as an advisor, as a consultant. He can also conduct antitrust audit. Various agreements are being executed by the companies, especially big corporates. He can do audit of those agreements, whether they fit onto the parameters, especially under section 3 and 4 or no. He can issue compliance certificate. He can conduct training programs because creation of healthy culture is the need of the country.